For those of you who don't know, we are an HR employee benefit consulting firm, and we work with about 350 companies in the LA area, but going as far north as Redding, California, and as far south as San Diego. And every month we have a webinar. Half the year we have outside speakers come in. In the last 2 months we had a employment lawyer speaking. Actually, 2 different employment lawyers speaking about 2 different topics. And those are up on our YouTube channel, so you can always go there and see those webinars. This month, we're talking about the new independent contractor ruling by the California Supreme Court. The minefield just got more dangerous. I stole that title from Karen Gabler, who's one of our sources for the information. She's with Light Gabler. So we'll start out with our usual disclaimer, which is the content of this webinar is provided solely for informational purposes. The information should not be relied upon as a substitute for legal, accounting, tax, or other professional advice. And this month, since we're talking about the Supreme Court ruling, I've added the line, please contact your employment attorney for legal advice. So this morning, we're going to talk about the California Supreme Court ruling, what it means, how it's supposed to work, and give you some examples of things that have popped up in the last few weeks. But again, this is a new Supreme Court ruling. There will be changes to it. There'll be interpretations of it. And so we may not have answers to all the questions. What I'm going to ask today is if you have a question, type it in the chat box. And at the end of the webinar, we'll try to get to the questions. If we don't get to all of them, we will answer all the questions and send you emails with the answers. The reason is that some of the questions that might pop up, we may not know the answers to yet because there's no clear-cut delineation as to how certain things work. So if we go to the next slide, we'll start out with our source material today, which is Karen Gabler of Light Gabler. The California Supreme Court adopts broad new classification. Ashton Riley at Fisher Phillips, another labor law firm. Sherry Shavitz at Tharp Howell. And then the Society of Human Resource Management, which also had a piece on it. So starting out with the Supreme Court ruling, on April 30th, there was a ruling that basically determined that an independent contractor, the rules are changing. They're not going to use a Borrello decision any longer, and they have a new ABC classification. It was an 82-page decision. And of course, it was worker friendly, as most things are in California. It affects all companies in California. And the question that came up in a meeting I had the other day was, well, what if I have an employee in Texas? Does it affect them or a contractor? And we don't know the answer to that yet, but we're going to find out. So the Fair Labor Standards Act have guidelines for independent contractors versus employees. And if you violate the new ruling, you could be having damages of back pay, overtime, legal costs, etc. So it's really important that you look at all of your employees and you reevaluate what you're doing if you have independent contractors or think about them. The court case involved Dynamex. And Dynamex was or is a package delivery service. They have drivers that go around and deliver envelopes, packages, boxes for other companies that are Dynamex clients. So 2 people filed a lawsuit and said that they're not really independent contractors, that they're really employees. Prior to 2004, Dynamex classified its California drivers as employees, but then converted to independent contractors. And so for the last 14 years, Dynamex have had these independent contractors. They drive trucks that have a Dynamex sign. They wear shirts that say Dynamex. Everything they do, they have name tags that say Dynamex, but they were considered independent contractors. And these 2 people brought a court case that went up to the California Supreme Court. And the California Supreme Court had a ruling that basically defines what an employee is. And it expands that definition. And it also imposes an affirmative burden on employers. So employers have to prove why somebody should be an independent contractor, not the other way around. And all California businesses should conduct a new evaluation of their workers to determine if they're properly classified. Having said that, the new decision has an ABC test. And the ABC test is now standard. So whatever the test was before for independent contractors, it's gone away. And a worker can be an independent contractor if it meets all three items on this page, A, B, and C, which is why we have A plus B plus C equals 1099. So first, the worker has to be free from control and direction of the hirer in connection with the performance of work. Second, the and would be they perform work that's outside the usual course of a hiring entity's business. And third, that they customarily are engaged in an independently established trade, occupation, or business. So they have to have their own business outside of your company or your client's companies. They have to have a P&L statement, have an independent business, have other clients. They're customarily engaged in an independent trade, occupation, or business. Second, B, they have to perform work that's outside the usual course of your hiring entity's business, which I'll explain in a few minutes. And C, that they do their own work and the hirer, the employer, the person who hired them isn't micromanaging what they do and how they do it. So those are the three tests, and it's an and test. So all three of these add up to an independent contractor, which is very different than the Borello test from before. So the courts place the burden of proof on the hiring entity. The failure of any one of the three is sufficient to make them an employee. So the advice that all the labor attorneys that I've spoken to have given in the last few weeks are, if you're not sure how to classify somebody, make them an employer. Bottom line, they're an employee. Make them an employee. Make them an employee, and then you can kind of figure out whether they should be or not in speaking to counsel. So I'm going to give you some examples that have come up in the last couple weeks, besides Dynamex. And the examples are things that either we have seen in our company with clients or we know about. So first we'll start with an architectural firm. We have a prospect that was an architecture firm, and they have 8 architects that are independent contractors. And the person who called on them said, you know, I'm not sure they can be independent contractors. And the owner said, well, they've been independent contractors for the last 10 years. And we met with this firm before this Supreme Court ruling. But because they do architecture work, which is what the firm does, because they're under the control of the owner of the firm that gives out the projects and oversees the projects, and because they only work for this architectural firm, they cannot be independent contractors under the new rule. The second example I'm going to give is in the entertainment industry. If some of you know, I have 5 kids, and the middle daughter started working for Viacom about 7 years ago. And for the first 3 or 4 years, she was an independent contractor. And Viacom hired people to do certain work, but they hired them as independent contractors. And then after the couple of years, if they wanted to keep them, they added new salary into their budget under payroll, and then they're offered a full-time position. While they're an independent contractor, they did not get benefits, did not get the usual things like vacation, sick pay, etc. And this is a good example, and this happens in the entertainment industry a lot, not just for companies like Viacom, but for production companies and editing companies that have people that work for them as independent contractors. As an example, we have a couple clients that are in the post-production business. And in the post-production business, they do work for TV, commercials, movies, and they do editing. And it's a seasonal business, especially around television season time. And one company we know, and I believe somebody is on the webinar right now, they hire them as seasonal employees, and they look at their hours and they make sure they're in compliance with the Affordable Care Act. But the other company we know hires them as independent contractors. which now under California Supreme Court ruling would not be acceptable. Another example is CPA firms. CPA firms hire a lot of seasonal workers for work during tax season. I just talked to a CPA firm a couple days ago, had breakfast with him, and he hires 5 people because they do 750 tax returns, and he hires them during tax season, and he hires them as independent contractors rather than as temporary workers or part-time workers or seasonal workers. And in the future, that's going to be an issue. But an example of an independent contractor that works is our company. We're an HR employee benefit consulting firm, and we hire someone to come in and do our books on Quicken, make bank deposits. He does his stuff every single day. As many days I don't even talk to him. He has his own bookkeeping accounting firm. He does about 150 tax returns. He does work for other companies in the bookkeeping area. He only works for me 3 hours a day. He can be an independent contractor. He does his own thing. I don't oversee what he does. I look at the products of what he does, and we're not in the bookkeeping accounting business. So that would be acceptable. Talked to somebody the other day that was a dentist, and this came up. A lot of dentists have dental hygienists that don't work full-time, that work for 2 or 3 dentists, and they may work 10 hours a week for one dentist and 20 hours for another. And the dental hygienist I talk to is an independent contractor. And that's another good example under the law that it's going to change. Now, one question that came up when we had an office meeting about this a couple days ago was, what if somebody retires or leaves your company? And we had somebody who was with us for 7 years, and she decided to move to Idaho where her grandchildren are. And what happens if during our heavy season, which in our business now is the 4th quarter, we decide to hire her for a couple months? And then it's a temporary assignment. We hire her full-time for 2 months, and then she leaves us. The question that came up was, is she entitled to unemployment insurance? Because we let her go. We laid her off. We're not hired. We don't have her for the rest of the year. And is she entitled to unemployment insurance? And the answer is, we don't know the answer to that. And I think what happens a lot of times with legislation, and here in this court cases, there could be a lot of unintended consequences or a lot of issues that come up that aren't answered because of the court case, and now we have to wait and find out what happens in a court of law. And so I talked to 3 employment attorneys about this in the last few days or week, and brought up this topic, and the answer was, we don't know. Are they going to be, are they entitled to say, I was laid off, and therefore I'm entitled to unemployment insurance, which then raises an employer's unemployment insurance rates? It's an interesting question. The next 2 examples are salespeople that are outside salespeople that a lot of times are independent contractors. One are insurance salespeople, and the other are real estate brokers. I'm in a group of insurance agencies around the country called Q4I. We have about 30 agencies that are all HR employee benefit firms in about 27 states. And in a number of states, they hire their salespeople as independent contractors. The salespeople run their own businesses, they have their own P&L, and they're just independent contractors. They don't work for anyone else, they just work for ABC Insurance Agency. In California, that's going to be an issue now. And now, if you're a property casualty agency and you also do personal lines like home and auto, and you also do benefits, then you have to hire salespeople. You can't have independent contractors. Now, we do work for a lot of firms that don't do employee benefits in HR, and those people that refer us business, we do give them a 1099, but all they do is refer us the business. We work with the client. They have their own practices. It happens to be property casualty or personal lines, home and auto, and they don't do what we do, and so that could be a gray area. But real estate brokers is a great example. A real estate firm up in the Thousand Oaks area had a picnic for all their friends last Sunday. We went to the picnic. There were like 100 people there. And this is very typical of what happens is that real estate brokers end up working for a firm but they're independent contractors and they run their own real estate practice. And that may become an issue in California. So, but if you're working for a Coldwell Banker or a Berkshire Hathaway and you get a 1099 and you get a percentage of the sales of what you do, listings and sales, etc., you're working for a company that does real estate sales, and therefore you may have to be an employee. Trucking delivery firms we've already talked about under the Dynamex decision, but I'll give you a great example. Bob's Discount Furniture's opened up in Southern California, and a few months ago they opened up with 5 stores on the same day, and my wife and I decided finally to get a new bed after 10 years, and we went and we got a bed from Bob's, and they delivered it. The truck said Bob's Discount Furniture with the logo that's on the screen, and the drivers, so I happened to ask them, are you employees of Bob's? And they said, no, we're an independent contractor. We only do work for Bob's, and we have to put their logo on our truck. Well, unless they're an independent contractor that does deliveries for other companies, if they only do deliveries for Bob's, they no longer can be independent contractors under this ruling. So it's going to affect a lot of people. FedEx Home Delivery is another one. I don't know if you know this, but everybody who delivers for FedEx Home Delivery is an independent trucking company that only does work for FedEx and isn't part of FedEx. That's another example. And then the obvious one, if you read all the literature and news articles about this, Lyft and Uber, and how they're affected in California. So those are some of the examples I'm using. I'm sure there's other examples that pop up that I haven't even thought of. A good example would be IT firms. We had an IT firm for 10 years that had about 40 employees but had about 20 independent contractors that did work. That would be a problem under the new law. So hopefully I've covered a whole bunch of scenarios here that will give you an example of what might happen under the new law. Let me move to the next slide. So when in doubt, make him an employee. If you're not sure, consult with an employment attorney. We refer our clients to 3 or 4 different employment attorneys, depending on the size of our client's company, if they're small, medium, or large. And so if you have an employment attorney, feel free to chat with them. If you need a referral to an employment attorney, we're happy to do that. But just remember that it should be a law firm that specializes in employment law. We have a client that has over 150 people, and he always, the owners, always ask their employment law questions to their corporate attorney. And a lot of times it's direct opposite of what an employment attorney would say. So just as a reminder, independent contractors perform work that is outside the usual course of your business, and they have to be engaged in their own independent trade occupation business and not the same business as an employer. The question always comes up, what if they're incorporated? It doesn't matter. So where this is really going to play out is in the gig economy. The gig economy is filled with a whole bunch of millennials that work job to job as independent contractors. There's over 100 websites on if you Google websites for gig jobs, you're going to come up with over 100. I actually Googled it yesterday to see what I came up with because someone said my number's low, and I had over 1,000 hits. So there's 1,000 websites I could go to about gig jobs. Intuit predicted that by 2020, which is only 2 years from now, 40% of all American workers will be independent contractors. So obviously in California, this has a big effect on the gig economy and what's happening. So if you hire workers temporarily for a job to do something and it's not in your normal course of business and they have other clients, you may be okay. But if you're hiring them to do what you do, that's a different story. So I'm going to move on to the next slide, which is, again, the ABCs. And I want to reiterate very clearly that it's A plus B plus C makes them an independent contractor. If they're A and B, they work under your control and they do their own stuff, and they work outside the normal course of your business, but they don't have an independent business and they only work for you, they're still an employee. If they are working without your control and they have an independent business, but they perform the same work that you do, they're an employee. So the scenarios can be A, B, A, C, etc., etc. But in order to be an independent contractor now, it's just A plus B plus C. Now, what Karen Gabler of Light Gabler has told me, and she spoke in front of a PIRA group, which is the Southern California chapter of the Society of Human Resource Management. She spoke a month or so ago, and she said that this really doesn't change anything, it just clarifies it. So it just makes it really clear and simple. You have to have A, B, and C to be an independent contractor. And factors not considered, because this question always came up. Well, I have a contract with them, and my contract says they're an independent contractor. Or they have their own business license. Or they're incorporated. Or I don't pay them hourly, I just pay them for a job. Those things don't apply anymore at all. So the factors that are considered are only going to be A, B, and C. Makes them an independent contractor. So of that, we're done with the slides. If anybody has any questions, please type in your question. I'll be happy to answer it. Somebody asked, this is a California issue. Do you expect other states to follow? Well, that is a great question. Usually, as California goes, so goes the rest of the country. So I wouldn't be surprised if other states follow suit, but right now there's nothing that I've read that says that other states are following right now. The court case is only 6 weeks old, and so we don't have any indication of what may happen around the country. We receive information from a number of HR publications and websites and emails from around the country, and we've had nothing yet. Somebody asked me to get the slides. As always, we will send out the slide deck to everybody on the webinar. It is being recorded, and so that will be up on YouTube with the slides hopefully by Monday. It might be up sooner. The person that asked the question happens to be a CPA, and we specifically sent this out to CPAs around the LA area that we know, because we believe that CPAs will find this to be an issue with many of their clients. I actually got an email last night from a woman who happens to be a client who has training sessions in regional centers for disadvantaged people who nonprofits who work with disadvantaged people, and they have seminars and they bring people in to do training, and everybody she has is an independent consultant. And she wrote me an email last night and said, I can't attend the webinar today, but I think every single one of my people needs to be an employee, and I'm worried about the future. So, it comes up in a lot of areas. Next question is, they have a corporation with an FEI number, which is a business that still have to be considered 1099. So here's the thing. If they have their own company and they have an employer identification number and they're incorporated or they're an LLC, if you do exactly what you do and they don't work for anyone else, and you don't control what they do, then they could be an independent contractor. But if any of those three items don't come through as a yes, then they're going to have to be an employee. So a good example would be a bookkeeping firm I know up in Agoura Hills that works for other CPA firms. And they do bookkeeping and accounting and QuickBooks training for companies of other CPA firms. Okay, so on the ABC test, they have their own company, they have their own clients, they have their own P&L, so that's a yes. They work independently of what a CPA firm does. The CPA doesn't oversee what they do, but the third test is they do exactly what CPA firms do, because CPA firms do bookkeeping, they do accounting, they do QuickBooks training and all that. So this firm in Agoura Hills, they pass A and B, but not C. I'm not sure what order I did it in. And so they're going to have a problem. So that's going to be an issue, whether they're incorporated or not. So this is one of those issues where, logically and with common sense, you would say, well, they got their own company, they have their own employees, therefore they shouldn't be employees of another company, but we're not going to know, and that's a case where I'll say consult with your attorney, and that may have to end up being a court case in the future. Are there any other questions today? Well, seeing no other questions, this was our quick webinar, a half an hour. Usually our webinars are 30 minutes to an hour. So next month we're going to have one on COBRA. That will be a long webinar. I'll be doing that one in the month. The basic comp and how employers get in trouble with work comp. Having said that, thank you for attending the webinar today. If you have any specific questions, feel free to email me or email your account manager or contact at Really Great Employee Benefits, and have a great day.